Hi everyone. Thanks for tuning in again and spending your afternoon with us. And this time with me is Joshua. Hi Joshua.
Hello, hello,
So
hello.
our
Got
topic
viewers
today
or not?
got
How many viewers we have now?
no we have five.
Wow, we have five.
I mean yes. So our topic
Mm.
today is on drug trafficking and the death penalty. And as most of us know, for the offense of trafficking dangerous drugs, if you are found guilty, the sentence would be a mandatory death penalty sentence. So on this note, today we'll be discussing two cases. The first is the case of Alma Nudo Atenza, and the second case would be Letitia Bosman. Both Alma Nudo Atenza and Letitia Bosman were both convicted for trafficking dangerous drugs, and then they were sentenced to death under the Dangerous Drugs Act 1952. As usual, we will be discussing these two cases in turn. First, Alma Nudo Atenza, then Letitia Bosman. Right. So for the case of Alma Nudo Atenza, she is a citizen of the Republic of Philippines. She traveled from Hong Kong to Malaysia by flight in 2014. So upon arriving at KLIA, she scanned her bag, and upon scanning, a customs officer saw a suspicious image inside the bag. Then the officers examined the bag further, and it was discovered that the bag contained several new handbags, and one of the handbags was removed, and a suspicious image inside the handbag was detected. And later, it was found that each handbag in the big bag was found to contain dangerous drugs packed in yellow tapes and concealed in the inner side of the handbags. And these substances were then sent to the chemistry department and were confirmed later to contain 2.5 kilograms of methamphetamine. And then the High Court actually ruled that two presumptions at the same time under the DDA can be invoked by virtue of Section 37 capital A of the DDA. And this means that a person can be presumed to have possession and knowledge of the drugs, and at the same time be presumed to be trafficking the dangerous drugs if it exceeds the statutory limitation. So the main issue in the federal court was the constitutionality of Section 37 capital A of the DDA, because this section appears to allow the use of double presumption to find possession as well as trafficking for a charge under Section 39 capital B. So Joshua, can you please share with us what did the federal court say in this case of Alma Nudo Atenza?
Yes. So as you have rightly pointed out, this case concerns basically one issue lah, whether Section 37A of the Dangerous Drugs Act is constitutional. Basically, Section 37A allows the use of presumption in addition to or in conjunction with other presumptions. So it may not only be a situation of double presumption, it may be triple or quadruple presumption. But just as a background, for drug trafficking cases, very often we come across the use of basically two presumptions. One is the presumption of possession under Section 37D. It's called presumption of possession and or knowledge, whereby if you are found to be in custody and control of a bag or package, then you are presumed to be in possession of the contents in that bag or package and to have knowledge of the drugs in the package or the bag. So that is a presumption of possession. And the other presumption is a presumption of trafficking. This is 37 DA of the Dangerous Drugs Act. Basically, there's a list of a threshold weight of drugs, and the moment the drugs exceeds that threshold weight, then it is presumed that you are trafficking in the said drugs. So the net effect of these presumptions when used together is that all the prosecution need to prove for a drug trafficking charge is that you are in custody and control of drugs, and that drugs exceeds the threshold weight. So that is sufficient to secure a conviction of drug trafficking. So it in 1998, there's this decision. So before we go into Alma Nudo, I think it's important to just talk about this federal court decision in Muhammad Hassan in 1998, where the federal court said you cannot use double presumption. You cannot use the presumption of possession, and then on top of that, you use the presumption of trafficking. Okay, um, that was in 1998, and Parliament, I think in 2017, enacted the 37 inserted or amended legislated section 37A to overcome Muhammad Hassan to allow the use of double presumption for drug trafficking cases. Right. So then in Alma Nudo, the appellant, of course, challenge that enactment, section 37A, as being unconstitutional. Basically, the challenge was on two grounds. So is that Parliament, in enacting Section 37A, has usurped the judicial powers. And number two, so three grounds. Number two is that it infringes the presumption of innocence of the appellant. And number three, that the Section 37A, the use of double presumption, is not proportionate. When you know that in accordance to Article 5 and Article 8 of the Federal Constitution. Now, so the federal court, this was a unanimous decision. I think it was delivered by Justice Richard Malanjun. Yeah, CJ at that time. So he held that Parliament, there was no usurpation of judicial power. Basically, Parliament Parliament basically did not, there was no overruling of the federal court decision in Muhammad Hassan. So the CJ then said that, in fact, by enacting 37A, the Parliament was complying with the direction of the federal court in Muhammad Hassan, because in Muhammad Hassan, the federal court said the reason why double presumption is not allowed is because Section 37D, 37DA uses the word if a person is found in possession of a certain weight of drugs found. So the word operative word is found. So the federal court said the use of the word found means that it must be an affirmative finding of fact as compared to deemed possession. Meaning, you cannot, to invoke 37DA, you cannot use deemed possession under 37D. It must be an affirmative finding of fact. So you must show custody, control, and knowledge of the drugs. So, and in Muhammad Hassan, the federal court said that it would be harsh and oppressive to use this double presumption. And they said, by the way, Parliament did not intend to allow the use of double presumption, because if it had intended to do so, it would have said it clearly in the act at the time. So that is why I think our Parliament inserted 37A. So that's why CJ then Justice Richard Malanjun said that actually the Parliament was complying with the direction of the federal court in Muhammad Hassan, and it is not an overruling of the federal court's decision. So that challenge on the basis of usurpation of judicial powers, that was dismissed. But more importantly, is that the challenge on Article 5 and Article 8, based on Article 5, Article 8. So CJ said in his judgment, he said that yes, the use of presumption is a violation of the presumption of innocence, because when you use presumption, the burden of proof, where in normal criminal cases rests on the prosecution, shifts to the defense. And on top of that, it imposes a legal burden in that the accused is expected to rebut that presumption on a balance of probabilities as compared to just raising a reasonable doubt and adduce evidence. So CJ said, CJ Justice Richard Malanju said, yes, there was this infraction of the presumption of innocence, but he said it does not mean per se, excuse me, that that it is unconstitutional. So then Justice Richard Malanjun went to Article 8 and the proportionality test. And he said that he went through this three-stage process, inquiry process, and the first is legislative aim. So CJ said that yes, the then CJ said yes, there is this valid legislative aim to curb drug trafficking activities. The second stage is whether there's a rational nexus, and the then CJ said yes, because when you allow the use of presumptions in criminal cases, then it will ease the securing of convictions for drug trafficking cases. Therefore, it will aid or facilitate in the effort to curb drug trafficking activities. The third part is a proportionality issue. This the CJ said no, it is not proportionate. Basically, he gave I think I can categorize it into four broad reasons. The first, he said that the decision in the federal court in Muhammad Hassan still stands in that the use of double presumption is still harsh and oppressive, given the nature and seriousness of the crime and the punishment it entails. Number two, he said that the use of double presumptions will, because as I explained earlier, the use of double presumptions will allow the prosecution to prove the offense of drug trafficking without proving certain important elements of the case. Yeah, most notably, knowledge of the drugs. So he said that when you allow the use of double presumptions, there may be doubts that exist over material aspects of the case. And then Justice Richard Malanjum also mentioned about the fact that even though Parliament enacted Section 37A, they did not amend the words in Section 37D and DA. So the words in Section 37DA to remove the word found to deem or anyone deemed to be in possession. So he said basically the rationale in Muhammad Hassan, the ratio in Muhammad Hassan was not overcome. And I think he also said that it's not proportionate because for the reason he gave earlier in respect of the presumption of innocence. He said that when there is this reverse onus on the accused, basically it is not proportionate to allow the use of double presumption for drug trafficking cases. So I think that is in essence the key points you can take from the decision of the federal court in Alma Nudo. Of course, I have certain reservations over the decisions, but yeah, that's what the federal court said in that case.
All right, thank you, Joshua. Let's move on to Letitia Bosman, and also to our audience today. If you have any questions, please drop your questions in the comment box, and we'll address them later at the end of the session. So Letitia Bosman's case, she was actually charged, convicted, and sentenced to death by the High Court for trafficking dangerous drugs, which is contrary to Section 39 capital B of the Dangerous Drugs Act. And the law makes it mandatory for courts to impose the death penalty for all offenders under the Section 39 capital B of the DDA. And in this case, a few issues were raised essentially on the mandatory death sentence itself. For instance, courts cannot exercise its discretion to prefer other sentence under the DDA since it's mandatory. So on this note, what did the federal court say?
Okay, so Letitia Bosman is a case. In fact, it was heard, I think, with another 3 or 4 more cases in the federal court. But all of the cases basically involve this constitutional issue, whether the mandatory death penalty is unconstitutional. So I think in Letitia Bosman, it was a 39B case. And then I think there's another 2 or 3 more cases, also 39B. And then there's one case on 302, murder. So I'm sure as you and probably the viewers would have known that or are aware that there are certain offences in Malaysia which carries the mandatory death penalty, like murder. 39B used to, but now it's no longer mandatory. I think there's treason, there's firearms, Section 300 Firearms, Increased Penalties Act, and so on and so forth. So basically, what mandatory death penalty means that once you are being convicted of the offense, then the court has no choice but to sentence you to death, right? So this is often compared to this phrase discretionary death penalty or this sentence discretionary death penalty, where the court retains a discretion whether to sentence you to death or sentence you to imprisonment, right? So the challenge in Letitia Bosman was whether the mandatory death penalty is unconstitutional. So the first challenge was, so the federal court's decision in this case was, there was a majority decision delivered by Justice Azhar, and then there's a dissenting judgment delivered by Justice Nalini. So the majority decision essentially said that it is not unconstitutional, right? So on the first point, they said the majority, the Justice Azhar said that uh, when you talk about usurpation, on the issue of whether there was usurpation of judicial power by Parliament in enacting mandatory death sentence, because the point is when it comes to sentencing, it is a judicial power. It is the court, after convicting an accused person, then proceeds to sentence a person. So by Parliament enacting legislation which allows for mandatory death penalty, basically you have taken away the discretion of in relation to sentencing from the courts. And that is the issue in relation to the usurpation of judicial power. So on that point, actually both the majority and minority decision of the federal court, they agreed that yes, Parliament has the power to enact or create offences that is given in the federal constitution. Parliament has power to create offences, and offences would, and the creation of offences would entail the prescription of the punishment. So it can be a range of sentence. So for example, maybe term of imprisonment for 2 years up to 5 years or 10 years, or it could be a mandatory sentence. For example, this mandatory death penalty. So both the majority and the minority held that there was no usurpation of judicial powers because Parliament, it was well within Parliament's function and role to enact, to create an offense and then to prescribe the punishment for that offense, right? And I think Justice Azhar went further to say that what is important is that Parliament is actually allowed to change or to enact the legal basis on which a judgment is based on. So as long as it doesn't alter the judgment and it doesn't affect the outcome of that individual case, that is not unconstitutional. It was well within the powers of the Parliament to do so. Justice Nalini agreed that yes, there was Parliament had the power, but Justice Nalini then said, but the legislation is of course subject to judicial scrutiny. If it's unconstitutional, then the court should declare as such. So that is in terms of the issue on separation of powers or usurpation of judicial powers. More importantly was this issue on Article 8 and Article 5, the challenge based on Article 8 and Article 5. So the majority said, Justice Azhar said that when we talk about death penalty, this concerns social policy, social and moral policy. So he said these are matters in which uh, Parliament would be the best for them to decide because they were elected by the people, and they are in the best position to decide on these issues and not the courts. So when Parliament enacts the mandatory death penalty, the court should then give what he calls judicial deference. The court should give proper weight to parliamentary exercise in determining what are the current social and moral values in society. So he said, although there may be, because in that case, I think council referred to certain surveys and certain articles where it shows that there are a cross section, a big cross section of society who sort of disagrees with the imposition of mandatory death penalty. But Justice Azhar said that shows exactly how divisive it is and why it would be best to be left in Parliament's wisdom to enact laws to reflect what is acceptable or unacceptable to society. Um, then the second point on Article 8 and Article 5 he made was that um, he said that there's a it satisfies the mandatory death penalty satisfies the reasonable classification test. So he said that this is because he said discriminatory laws are allowed as long as there's reasonable classification. And he said that the reasonable classification is that he said the focus should not be on moral blameworthiness. That was the term he used, meaning that the focus should not be on the facts or circumstances of each individual case. So he said that the reasonable classification was that this group of individuals are given equal punitive treatment for similar legal guilt. Means they were all convicted of murder, hence they were treated equally. So that was his focus. In terms of the fair trial issue, the first challenge raised was mandatory death penalty would deprive the accused person a right to mitigate, to put forth mitigating factors during sentencing. So to this, Justice Azhar replied that when it comes to mandatory death penalty cases, mitigating factors or submission of for mitigating factors during sentencing, there's no use for it. It's redundant. So, and he said that whatever mitigating factors you have can be raised in the pardons board for clemency, for a petition for clemency. And he said that when you talk about deprivation of the right to mitigate in contravention of Article 5 of the right to life in our federal constitution, he said that Article 5 is basically qualified, safe in accordance with law. So he said Parliament can enact laws to take away that right. So that was his answer to that point on deprivation of the right to mitigate. The second point on the right to fair trial raised was that mandatory death sentence is arbitrary in the sense that there's no discretion given to the courts to tailor the sentence sorry, to be commensurate with the facts of each particular case. So basically, it doesn't matter what the extenuating circumstances for the case is, as long as you are convicted for murder, then you should be sentenced to death. So again, he said that his answer to this was that Parliament, in its wisdom, has considered the social and moral values in enacting the mandatory death penalty. So it's not arbitrary because it was debated in Parliament and Parliament, enacted such laws. The third point was that the death penalty was a cruel and inhuman treatment or punishment to a person being sentenced to death. So Justice Azhar, on this point, he said that Malaysia has never ratified. Number one, he said there's no provision prohibiting cruel, inhumane, and degrading treatment or punishment in our federal constitution. That's one. Number two, he said that Malaysia has never ratified or acceded to UNCAT, I think United Nations Convention against torture, all that lah. So he said there's no accession to Malaysia did not ratify that convention, so it cannot be imported and made into Malaysian law. So he said, so the term, so he said this challenge basically cannot hold in Malaysia. So that was the majority decision in terms of Article 8, Article 5. Justice Nalini, this is where Justice Nalini dissented. Justice Nalini said that for all cases, for 39B and for 302 cases, the facts and the extenuating circumstances of the case is very important. Because she gave example, I think she gave two examples for each an example for each case for 39B and 302. So for 39B, she said there could be a situation where the person is merely a drug mule, just carrying certain drugs. And then at the other extreme, there may be someone who's actually operating a lab, cooking the drugs. So he said there are these two extremes of drug trafficking activity. And, the law must give heed or must recognize that there is this difference in involvement. And this is where it is important for the courts to have discretion in sentencing. Because when you allow mandatory death penalty, basically you will disregard any extenuating circumstances of the case. As long as you are convicted for murder, it doesn't matter what was your involvement, what was the weight of the drugs, whether it's 15 grams or whether it's 1 kilo or whether it's 100 kilo, you will still be sent to the gallows. So that was a point in respect of Article 8, Article 5. Her focus, like I said, Justice Azhar focused more on the culpability, that because these people were found guilty of the offense, so they should be punished equally. Justice Nalini had a different view, so she focused more on the sentencing. So she said because of these facts and circumstances of the case, that there must be discretion in sentencing. And then she also said that the death penalty was disproportionate and in contravention of Article 8. So she gave 3 points. She said the accused may be deprived of the hurt to be heard in terms of mitigation during sentencing. Number two, there is no opportunity for which is also related to the mitigation point, that there is no opportunity given to the accused to justify to the court why death sentence is not warranted, why he should be given a lesser sentence. And number three, she said that the mandatory death penalty would render the circumstances, the extenuating circumstance of each particular case redundant, right? So even in 302, she gave that example, which I forgot to mention. She said at one extreme, you may have, a violent killing, someone who's maybe a serial killer, and then at the other extreme, you may have someone who probably pulled the plug on a loved one because, he doesn't want to see that person suffer. And she said, in both cases, it may be 302, it may be considered as murder. So she said, it would be unfair for the law to not make this demarcation or to not recognize this difference between these two cases. So the net effect in that case, basically the federal court, because Justice Nalini was in the minority, so the net effect was that the federal court held that the mandatory death penalty is not unconstitutional, right? So I think because of the time constraint, those are the key points I think that can be extracted from the judgments. It's quite a lengthy. These two cases are quite lengthy judgments. You know, if you are free to, if you have run out of movies to watch on Netflix, then of course you can read those cases lah. It's published in the law journals.
Yeah.
Thank you.
Thanks, Joshua. It's very elaborated. We have a question. Let me put it on the screen. Thanks for the explanation. So from now on, the position is that we can expect there can be no usage of double presumption against us, right? Because it's unconstitutional. I think it's just a clarification.
Yes, the short answer is yes. But I would think that it is only in respect of the use of section 37D and TA. So it's presumption of possession and presumption of trafficking. Because I think there is this one issue which was not considered by the court. In section 37, of the Dangerous Drugs Act, there's a list of presumptions. So there may be other presumptions which may be used in conjunction or in addition to other presumptions, right? So, for example, if you are in care or management of the premise, then you are deemed to be the occupier. Then there's another presumption where if you are the occupier of the premise, then you are presumed to know what is in the premise. So, but I think because the federal court basically declared that section 37A is unconstitutional. So yes, I think you basically can't use double presumption. You can only probably use one presumption in a case. In Alma Nudo, I think Justice Richard Malanjum actually mentioned that because the issue on the constitutionality of the use of a single presumption was not raised, they are not deciding on the issue. So basically, there is this opening that there is still room to argue that the use of presumptions, maybe the reverse burden aspect of the presumption is unconstitutional. Even the use of a single presumption, because of the seriousness of the case and the punishment it carries. Thank you. I hope that answers your question.
Okay. Yeah, I hope it answers you, Yuzi. Anyways, like what Joshua said, because of time constraint, I think we have to end here. So thank you everyone for joining us today. Thank you, Joshua. Today we've learned a lot about death penalty and drug trafficking. I think that's a lot to digest. And this might be our last episode for What Did the Federal Court Say, but stay tuned on our Facebook page if we're going to have this anytime soon in the future.
Yes. So, if you want to know more about drug laws, I think I've written an article on Ask Legal. You can look up for the article. It's a very basic article that gives a basic overview of drug laws in Malaysia. Thank you.
Yeah, all right. So thank you, Joshua, and thank you, everyone. Have a great day ahead. Bye.
Bye.